Welcome back, my gorgeous, good looking friends. This is a follow up to my previous video that I did on the update to the Markle versus Markle defamation lawsuit, in which now Samantha was granted to have the oral argument requested on November 8th at 1:30 p.m. in Tampa in a courtroom in front of the judge. Well, today we have an update. And of course, pain in the ass Meghan Markle has decided to file a motion in order to do this oral session over Zoom. Now, I want to go over the couple of pages and their reasoning for why they want to do this. And I'm going to share my thoughts on it because I think that this is an important point for us to think about and discuss. Now, again, I'm not a lawyer, so whatever Samantha's team is doing as far as strategy goes, that's on her. I'm just observing what has been going on and just giving my thoughts on the situation. I'm going to read this out because it's fairly short. It's important that we understand what is being asked here. So it says, pursuant to Middle District Local Rule 3.01H, plaintiff Samantha Markle and defendant Meghan, the Duchess of Sussex, by and through her respective undersigned counsel of record, hereby jointly request that the oral argument scheduled for November 8th, 2023 at 1:30 p.m. on the motion to dismiss the third amended complaint and the motion for miscellaneous relief, specifically for judicial notice in support of motion to dismiss third amended complaint, partially unopposed, be conducted via Zoom video conference. Now, I'm not sure if this was indeed a joint agreement that both of them want to have this session over Zoom, but I'm going to share to you why I think this is not a good idea. Continuing on, though. Good cause exists for the requests made in this joint motion. Lead trial counsel for the parties who will be participating in the oral argument on November 8, 2023, Peter Tickton for plaintiff and Michael Kump for defendant, reside outside the Middle District with Mr. Kump in Los Angeles, California. Personally, at this point, I don't think any kind of courtesy should be extended to Meghan's legal team, considering how rude they have been to Samantha from the very beginning of this case. And in addition to that, Meghan, being so difficult by throwing all this deflection and paperwork for the judge, should not have the chance to control the situation. And in this case, it was Samantha Markle who requested this oral argument. Why give Meghan's team an ounce of control to dictate how this oral argument's going to go down? In my opinion, it's too fucking bad that it's inconvenient for Meghan's team to fly to Florida to be there in person. I think it's good if they take them out of their comfort zone. Yeah, so it's not convenient. Well, if the situation was reversed, I highly doubt Meghan's team would care if this was inconvenient to Samantha's team. In fact, they would probably force the issue to make sure that they were there in person just to drive up the cost. And I'm not buying that cost is an issue because Meghan can very well put her lawyer on a private jet and send him to Florida. I mean, we've been seeing Meghan gallivanting all over the place via private jet, so now is not the time to be cost conscious or thinking about saving the planet, okay? It goes on to say, conducting the oral argument on November 8, 2023 by Zoom video conference will not require any travel and will be more convenient. In addition, the prior oral argument in connection with the motion to dismiss the first amended complaint was set by the court to proceed via Zoom video conference, see docket 57, and was successfully conducted on February 15, 2023 via Zoom video conference without any issues or other impediments. And finishing this off, memorandum of law, the court has the power and discretion to conduct court hearings and oral arguments in civil actions via video conference. This is particularly true where, as here, the parties through their respective counsel of record have requested and agreed that the oral argument set for November 8, 2023 be conducted via video conference. Among other benefits, conducting the oral argument via video conference will be more efficient and convenient because it will not require the parties' respective lead trial counsel to travel to and from the Middle District. Furthermore, as shown by the oral argument conducted on February 15, 2023 via Zoom, conducting the November 8, 2023 oral argument in the same manner will not cause any issues or problems and will allow all counsel and the court to fully participate in the oral argument. Now, here's why I think this is a bad idea. Let's go back to the hearing that they're referring to back in February. The last oral argument was initiated and put in the calendar by the judge. It wasn't a result of Samantha or Megan requesting to have this oral argument to hear and get this case dismissed. This time around, this was Samantha's initiation. She wanted to have this oral argument, which was submitted back in July after Megan had been submitting all this extra stuff for the judge to look over and trying to water down Samantha's case. Now, let's all remember that the first go around with this setup in having an oral argument via Zoom resulted in Samantha's case to be partially dismissed with prejudice. Now, the reason why we're still talking about this was because the judge did see that the Oprah claims did have some sort of ground to it and gave her 14 days to amend this complaint in order to move forward with this lawsuit. Now, I think Michael Kump, Megan's lawyer's opinion here, is a bit distorted, in which he says, furthermore, as shown by the oral argument conducted on February 15, 2023 via Zoom video conference, conducting the November 8th, 2023 oral argument in the same manner will not cause any issues or problems and will allow all counsel and the court to fully participate in the oral argument. Well, I think that he has selective memory because in that oral session via Zoom, there were some problems that I could see affects the continuity, the flow, the energy. Let me show you what I'm talking about. In the court transcript from that day on page 8, Mr. Tickton gets a chance to speak before the judge, and if we look at this paragraph where it says Mr. Tickton, this is Samantha's lawyer, it says, yes, well, in considering, it's in your honor's discretion to take judicial notice of those facts. And that means that it's not an automatic yes any more than it is an automatic no. Okay, and he goes in, he gets into this story, and he gets into a groove. And later he says, we're saying it's not true, but the fact that those words are said rather than just the chapter existed, I think, and he continues on. I think that the chapter should come in as evidence in order to be considered, meaning finding freedom. But when you look at a New Mexico case where, Samantha Markle admits and agrees that she used her married name in her divorce work, in cases or situations where the married name would be appropriate name to be used, but she used the Markle name in the midst of all of this. It's kind of like the same thing they could toss back with Meghan, the Duchess of Sussex, really should be changed for this legal document to Meghan Markle or whatever her married name is for official purposes. Using that title is ridiculous in a case in the United States, just because we don't honor those titles. Anyhow, and we attach some exhibits to our response to the motion to dismiss that basically proves that. So I don't know that we're going to get into an agreement or disagreement as to certain facts here, so much as the legal argument that I think needs to be argued in terms of the motion to dismiss. Now, remember, all of this is coming across via Zoom. So he's not able, in my opinion, like many, to read the response of the room, whether it be looking at the judge and getting her facial cues to really try and connect with her, as one would face to face. In addition, you're not able to fully read what your opponent is doing. So if, let's say, you're in a room all together, you can watch the body language and behavior of the defendant, or watch the body language as well as the microaggressions of the judge up close and personal. Sometimes that is lost when you do this kind of stuff over Zoom. And nothing's worse when you're in a flow and you're about to make a valid point, technology fails on you. And that's exactly what happened in this session. Samantha's lawyer continues and he says, if we look at the fact that in 2016, the timing, I have no objection to this court considering the timing. So then the court starts to speak, assuming that that's the judge. It replies, okay, wait just a minute. Excuse me, Mr. Tickton, we lost you. I can hear you, but your camera is no longer on. And I like to always be able to look at attorneys when they're arguing, even if it's via Zoom or in the courtroom. So I need you to come back to the camera. So, even in this little insight here, which I hope the lawyers have picked up on, this judge does want to establish a connection and to understand where everyone is coming from. She's stating that she wants to look at you. She wants to see how you're speaking, how you're behaving. So then Mr. Tickton, Samantha's lawyer, replies, "Okay, Your Honor, I just needed a minute. I don't know exactly what went wrong, Your Honor. I just pushed every wire back together again." Court says thank you, and it worked. You may resume. And from there, he goes on to make his point. But when you break concentration like that, you sort of disrupt the vibe and the persuasive argument process in convincing someone why they should take your side. Also, another drawback to doing this via Zoom is those pesky journalists that Megan has, or the propagandists who had, let's not forget, Smelly v. Hall, who had been live tweeting when it was against protocol of the court system in Florida. This journalist was in violation of Local Rule 7.02 of the court because she was live tweeting this. And it specifically says photographing, recording, or broadcasting of any kind during a court proceeding is prohibited. So even if she was allowed to use her device, she was not allowed to be broadcasting any of this during the proceeding as it was going on. And no doubt, if they have another session via Zoom, the same thing's going to happen. Now, Smelly Hall is out of a job, so naturally I would think it would be Jack Royston who would step in this time around to do the live tweeting, minute by minute narrative twisting. Remember, these are the same people who collaborated together with Boozy to smear Samantha, so why give them any opportunity to be a part of this? This is another reason why I think it's a bad idea that this is done over Zoom, because Tom, Dick, and Harry can jump on and report on it. As you can see, Jack Royston is all over this today, so there's no doubt that he is going to want to get the scoop and try to spin this narrative to push Meghan's propaganda. Let's not forget that he was also a part of the smear campaign with Samantha, and I do think that these journalists should be held accountable for what they did. The coordinated campaign resulted in specifically attacking Samantha and getting her banned off of various social media platforms like Twitter. Now, let's not forget that Ellie was part of amplifying that Bot Sentinel report. In fact, she was colluding with the CEO of Bot Sentinel to get that report together and was designed to discredit Samantha. Now, we all pretty much can guess who was behind paying those folks in putting together this plan and executing it. So now getting back to this motion that Meghan filed today, the last part says counsel for plaintiff, aka Samantha, and defendant, aka Meghan Markle, have conferred regarding this motion, and plaintiff and defendant, through their counsel of record, jointly request that the oral argument scheduled for November 8th, 2023, on the motion to dismiss the third amended complaint and the related motion regarding judicial notice be conducted via Zoom video conference for the reasons set forth in the motion. So, from what this says, it sounds like the lawyers had spoken and they both have agreed that doing this over Zoom would be okay. In my personal opinion, which means absolutely nothing, I think this is a bad move. I think at least it should be offered to give the option to attend via Zoom and have the opportunity to attend in person as well. Now, the one thing I'm not sure of is if the plaintiff and the defendant are supposed to be present for these oral hearings, or if it's just the lawyers speaking in front of the judge. If that's the case, then I can understand the argument for doing this via Zoom, but I still think having that face-to-face contact live with the judge is so important, because in this situation, this persuasive argument, you need to convince the judge, aka you have to sell the judge on why your position makes more sense than the other position. This is just sales 101, and I do think establishing a connection, whether it be understanding and reading the nonverbal cues on if, let's say, the judge is buying what is being told, to get them to move in the direction that you want them to. It's very hard to do that over video and gauge whether or not the person that you're talking to is comprehending everything that you're saying in the way that you want to persuade them to understand it to be. I think the option should be given if they want to attend via Zoom, they can do so. And let it be if Megan's lawyers don't want to fly out to Florida and do this over Zoom. Personally, I think it would work to Samantha's advantage if she could be there in person so the judge can physically see her and let Megan's team do it over Zoom. I think having that connection with the judge face to face is valuable in this situation. Remember, this is Samantha's last shot to get this case to move forward and get the justice that she deserves. Why would you chance messing that up? That's my opinion. You've come this far, you've fought so long. Do everything you possibly can to sell this, to get it to the next stage. If I were Samantha's team, I would review what happened in the last oral argument to figure out what you can prevent from happening again because you want a different outcome. Something so basic like technology not working could totally crush you. Don't take that risk again. This is just my opinion, guys, but what do you guys think? Do you think this is a valid argument? And do you see where I'm coming from? Or do you think that doing this over Zoom would be better? Leave your thoughts below. I just wanted to give you this update. As always, I will be back with more content, but until then, please be safe, and I will talk to you later. Bye.
It was such a fraud.